Hello and welcome to the closing ceremony of the International Virtual Mediation Summer School 2022. A very warm welcome to this closing ceremony, which also coincides with India's 75th Independence Day being celebrated today. The summer school this year was inaugurated on 5th of August 2022, with Justice L. Nageshwar Rao as the chief guest, with two guests of honor being Ms. Renee M. Baptiste, President of the St. Vincent Bar Association and co-chair, ADR Committee of the Commonwealth Lawyers Association, and Mr. George Lim, Chairman of the Singapore International Mediation Center. In the past 9 days, we have had an intensive impartation and sharing of knowledge by our course faculty who spoke on a wide variety of subjects related to mediation. Between 6th August to 14th August, we have had 9 very distinguished faculty, starting with Ms. Archana Medekar from Canada, who spoke on historical perspective of dispute resolution, development of legal systems, culture, followed by Mr. Ajay Mehta from India on 7th August, who spoke on ethics and ethical issues in mediation, along with confidentiality, neutrality, and self-determination. On 8th August, we had Sarah Blake from Australia, who spoke on conflict and styles of conflict, conflict management resolution and transformation, followed by Professor Joel Neal from Singapore, who on 9th August spoke on communication skills needed for a mediator, both verbal and non-verbal communication. Then we had Ms. Chitra Narayan on 10th of August, who spoke on introduction to mediation, definition and process of mediation, differences between mediation, conciliation and arbitration and litigation, and lacunae and disadvantages of adversarial dispute resolution. On 11th of August, Mr. Jawad Mohammed enlightened us on negotiation, soft, hard and principled negotiation, negotiation skills needed for a mediator as a facilitator of negotiation and conclusions and agreement in mediation. On 12th of August, Mr. Andrew Miller from England spoke on online mediation and the advantages and disadvantages thereof. On the 13th of August, we had Ms. Alusola Barrister from Nigeria and Mr. JP Singh, Senior Advocate from India, who spoke on mediation advocacy. And we are very thankful to them for sparing their precious time from their busy schedule at a very short notice. And finally, yesterday, we had from Singapore, Mr. Gregory Vichendran, who spoke on future of mediation, the Singapore Convention and legislation on mediation. Today is the concluding session and closing ceremony. We have Mr. Jitendra Sharma, who will give us the opening address, followed by Mr. Brian Speers, who is the current president of the Commonwealth Lawyers Association and the guest of honor for today. We are very fortunate to have amongst us Honorable Justice P.S. Narasimha as the chief guest and Mr. Sanpreet Singh Ajmani, advocate and mediator and head of the Youth Bar Association of India, to give us the closing address. I now call upon Mr. Jitendra Sharma, who is a former Vice President, Supreme Court Bar Association, and a senior advocate, to please give his opening address.
Thank you, Shesh. First of all, I must say happy 75 Independence Day to all of you, to all Indians who are here and abroad, and to all our friends. On behalf of Nivaran, Supreme Court Mediators Initiative, the occasion of conclusion of our third summer school, I thank Justice P.S. Narasimha to preside over this function, who is known for his human nature, and Brian Speers, the president of Commonwealth Lawyers Association, and a very close and trusted friend who has always helped us whenever need arises, and who has been on our side whenever we thought of any webinar or any program to go for. He was the one of the first and earliest who would render his helping hand every time. I must welcome all the participants, those who have been here for the almost 9 days, 10th day, today is 11th day, who are here from across the world, starting from India, they're from Caribbean, from Australia, and from Africa. I welcome you all and to this concluding session. When the second session of our summer school was inaugurated by Chief Justice N.V. Ramanna, at the time of his inauguration, he said that the mediation centers and Lok Adalats have the potential to transform the legal landscape of India by providing millions of people a platform to settle their grievances. He prescribed mediation as a mandatory first step for resolution. Is a land where there is a dispute resolution through a mediation has been quite prevalent. And there are norms starting from, there are instances where you will find that mediation has been attempted. The earliest we remember in Mahabharata, where Lord Krishna tried to help to bring peace between the two warring groups, Kauravas and Pandavas. The second one, which I just, apart from other instances, the second one being of Lord Gautam Buddha, where he tried to bring in peace between two kings, those were Shakyas and Kolis, with regard to a river water dispute. And the third, which I would like to emphasize, is a written document. It goes back to 16th century, where there is a kingdom of Banaras, where the king of Kashi was known as Banaras. Banaras is known as Kashi in those days. The king of Kashi requested Tulsidas, the great poet who has written Ramcharitmanas, to mediate between two families. And that family belonged to Todarmal. I'm not in a position to say that this is the same Todarmal who was a courtesan in the kingdom of kingship of Akbar. But there is a Todarmal and there is a written document. This document you can find in the Allahabad High Court Museum, and it is preserved there. That's the first written settlement mediated by Tulsidas. So in India, there is a mediation has been found to be an accepted norm and an ethos, Indian ethos accept this settlement. However, the mediation which has been practiced in amongst the earlier days in India, through the panchayat system or otherwise, is slightly different from what is being accepted today as a mediation, what we accept as a norm today. Today, the mediation is being considered to be a facilitator, helping both the parties to facilitate its amicable settlement between the parties. While in the panchayat system, there could be an element of peer pressure or some influence of otherwise. However, in the modern day mediation, the mediator has got no role or no pressure upon the parties, and parties are absolutely independent. This being the state of affairs, mediation has become a norm of a first step entry where the dispute resolution could be entered into it. Nivaran, a Supreme Court mediators initiative, has been promoting mediation through awareness by holding lectures, webinars, and other functions which are there. In fact, almost 2.5 years back, that was in January, before the coming of COVID, we started a physical series of spreading knowledge, where it was a function organized by Nivaran. And the first one was presided over by Justice S.K. Kaul, and Justice Hima Kohli, who is now a Supreme Court judge, and Andrew Miller was our speaker. However, then came the pandemic. And after pandemic, the Nivaran is going into, we have just 3 sessions of charting the path of the future of mediation and charting the path for future mediation. We have given 3 series for that lecture. One is specifically for female mediators, and second was only absolutely on sports. The second, we started the lecture series, which was first initiated by, the first lecture was by Justice Vashisht Kokaram, and he propounded the concept of development of peace jurisprudence. The interesting part is that he said that the mediation would expound a peace jurisprudence apart from all other adjudicatory processes. This concept of peace jurisprudence was so much embedded among the mediators that even in the 3rd summer school, and some of our friends did mention Justice Vashisht Kokaram and said about the peace jurisprudence. Then these all lectures, till now we have gone about 18 lectures where different speakers are there, and they have delivered their lectures. And this is then came a summer school. Our friend from Commonwealth Lawyers Association, Speers, and our Youth Bar Association friends, they came up with 2 years back, they suggested that why not we go for a summer school. And in 2020, we started a summer school. And then it is a 3rd summer school. The last year was the second summer school, and today is the 3rd summer school. My friend Shesh has acknowledged the work and the initiative by the speakers, those who have really helped us in giving this summer school. I will be failing in my duty if I don't acknowledge their name once again. I thankful and I thank Archana Medekar, Ajay Mehta, Sarah Blake, Joeli, Chitra Narayan, Javed Mohammed, Andrew Miller, Alu Sola, JP Singh, and Gregory Vijayan. Above all, the first inauguration was by Justice Ellen Rao and George Lim. George Lim is the chairman of Singapore International Mediation Center. And it was another guest of honor was Rene Baptiste, president of St. Vincent ADR Bar Association, and as a co-chair of ADR Commonwealth Lawyers Association. Apart from these speakers, in an audience, we had a number of guests, and few of them I'll acknowledge. One was Mr. Peter Menard, is the vice president of Commonwealth Lawyers Association, and there were numbers of audience from SIMC, Singapore International Mediation Center. I welcome, and the members of Commonwealth Lawyers Association. I welcome them all, and I once again through this session, I just acknowledge their presence, their work, and I would be failing again in my duty if I just say that without the presence and without the efforts of our mediators, the team Nivaran, without whom, in whose absence, these webinars, these summer schools could not have been organized. So I thank you very much, and thank you very much to its conclusion. And I look forward the next year again for another summer school and continuous lectures. And I expect this all support which have been given by our friends from the CLA, Commonwealth Lawyers Association, and Singapore International Mediation Center. Thank you so much.
Thank you very much, Mr. Jitendra Sharma, sir. And thank you very much for bringing us all updated on all the activities. Mr. Brian Speers, President of the Commonwealth Lawyers Association and the guest of honor for today. He hails from Belfast, Northern Ireland. He's a seasoned mediator and trainer and very well known in the United Kingdom and Europe. May I call upon Mr. Speers to kindly address the gathering?
Well, thank you, and Honourable Justice Narasimha, wonderful colleagues, mediators and students, and the members of Team Navaran. It is a great delight to be here at your closing ceremony for what has been an inspirational and brilliant 9 days of summer school. It is never a burden to learn, to relearn, to have learning refreshed, and to learn new things. And I found all of that happening to me during the last 9 days or so. It is my honor to have been asked to take part in this closing event, and I propose to offer my brief reflections on the program, but also to offer some thoughts from a Commonwealth lawyer's perspective on the way forward for mediation. Can I just thank Santan and the Nivaran team for pulling all this together. Having organized 1 or 2 conferences and events, I know what goes on behind the scenes, and it really has been magnificent. And I know that somewhere in the background is my friend Rahul, and I'm sure that he is there keeping everybody running smoothly in the background, and I would like to acknowledge him and say hi. Starting with mediation in the Commonwealth Lawyers Association is, as you may know, deeply committed to upholding the rule of law, ensuring access to justice, and ensuring the independence of the legal profession and the judiciary. It requires every jurisdiction to be vigilant and not complacent about these important principles for our justice system. The CLA has formed close links with the Commonwealth Secretariat. And at the recent CHOGM, or Heads of Government meeting in Kigali, Rwanda, the CLA presented a joint event on the use of technology in ensuring access to justice. And mediation was mentioned in that context and will play its part in ensuring access to justice. The Secretariat last held a Commonwealth Law Ministers meeting in Colombo, Sri Lanka in November 2019. At that meeting, there was presented a very detailed and impressive report on arbitration. And it was said, and rightly, that effective methods of resolving dispute between Commonwealth members ensures that investments proceed, that there is a degree of willingness to take risks on investment, knowing that there is an effective dispute resolution system in member states. I raised the question as to why there was no similar report commissioned on mediation. And if we wind the clock forward from November 2019 to now, we find that just around the time, shortly before the Law Ministers meeting, the Singapore Convention had been initially signed. And now, of course, it is being picked up by more member countries. Most recently, of course, has been the United Kingdom. But we also can report that there is a commissioned report on mediation in the Commonwealth. And again, its justification is to encourage trade, to encourage an atmosphere of resolving issues between investors and corporations with business in other jurisdictions. And to my mind, that is a great welcome. The CLA have recently formed some special interest group committees, and we have co-conveners, both of whom are present today, regarding the Mediation and ADR Committee. So I acknowledge, of course, Santan, but also René Baptiste. Great to see you, René. Hi. Who is going to co-convene the CLA ADR / Mediation Committee. And I look forward to participating in its work as we both advocate for mediation, and we also promote the use of best practice in mediation across the Commonwealth. At our conference next March in Goa, we will have some mediation sessions. And I very much hope that many of you listening to this evening or in your time will contemplate attending our CLA conference in Goa next March. The arrangements have been laid, and all we need now are excitable delegates willing to soak up the brilliant sessions that have been planned. The integration of mediation in civil justice got a very significant wind behind it from the Master of the Rolls of the United Kingdom, Sir Geoffrey Voss. He spoke to the second Commonwealth Mediation Conference in my home city of Belfast in May just past. Several of the contributors to this Nivaran summer school attended personally in Belfast. We had George Lim present. We had Sola present from Nigeria. We had Jawad present. And we also, of course, had Santan. And in addition, Peter Maynard, our vice president, made it over to Belfast, who I see has been attending regularly this summer school. But it is perhaps the remarks of the Master of the Rolls of the United Kingdom that really resonated with me when he described a system of civil justice as not having alternatives, as in alternative dispute resolution, but rather having appropriate methods of dispute resolution, whereby litigation would coexist with the private court adjudication system of arbitration, as well as the dispute resolving approach of mediation. And I was delighted to see, firstly, a separation between arbitration and mediation. They are completely different. And yet for many years, they have been lumped together as ADR. But we mediators know they are completely different systems. One is an adjudicative decision-making process from which it is difficult to appeal, and the other is a facilitative quest for an honourable resolution between parties who willingly agree to a resolution. But that recognition that the Master of the Rolls gave in Belfast for civil justice thinking in the UK presents a three-legged stool, if you like, to support civil justice. We have the court system, often delayed, often expensive, but nonetheless still vital and important. We have arbitration and we have mediation. And between these three methods, civil justice and commercial justice can have appropriate opportunities for resolution. Cases resolving honorably in mediation are no less providing of access to justice than being in court. And I was delighted that Jitendra has referenced our old friend Vashisht Kokaram in his welcome and opening remarks when talking about peace-building justice. And that's a very important theme, which I wholly endorse and espouse. I believe justice and access to justice can be found in mediation and is not only found in going to court. Parties in a mediation feel respected, listened to. They have been granted the opportunity to make their views known, sometimes to exhibit their emotion and feelings, and are content to rely on the resolution as bringing an honourable end to their dispute. So I take the view that with the Commonwealth Secretariat report, the Commonwealth lawyers' interest in mediation, this wonderful and world-leading Nivaran initiative from India, the Singapore Convention and the Master of the Rolls speech in Belfast, to name just a few of the influences bearing down on mediation at present. We have mediation in a prominent, respected, and central position in civil justice. But with that acknowledgement comes the need for training, for ethics, for quality of mediators, and for the training in our law schools of lawyers to understand and know the adversarial system, but also to be acquainted with the concept of lawyers as peacemakers. And that brings me to reflect briefly on the sessions that I have heard, if I may. We had a marvelous talk on ethics, emphasizing that the mediator in a mediation should not be the central figure. It's not all about me, the mediator, the number of cases I have resolved, or the record I have of success. And I will look forward to listening again to the wonderful talk from A.J. Mehta on mediation ethics, which was, to me, inspiring indeed. When asked what I consider to be the most important quality of a mediator, I often reply, effective listening. I don't know that I would be able to reply that after listening to Professor Lee on his communication. There was so much going on about body language, about eye movements, about how to mirror and frame your body position when you're conducting a mediation, that I, again, need to listen to Professor Joel Lee's talk to fully absorb his wisdom. And it is not so easy to have mediation and a mediation community if parties' representatives do not understand what mediation is and do not have a strategy to advise their clients for dealing with mediation. And again, the talks about mediation and dispute strategy, the basic guide to mediation, and the talk from Jawad on negotiation, were all fantastic supports to reassure us all if we're getting the hang of mediation and to refresh our knowledge. We are meeting today by Zoom, which is brilliant. I don't have to move from my office in Belfast, and you are all sitting at home across the Commonwealth, from the Caribbean to Australia, listening in. But it has its limitations. And I thought Andrew Miller's talk just a couple of days ago was very practical and down to earth. And I look forward to many more in-person, both conferences and mediations, to get the benefit of real face-to-face interaction. Yesterday, our CLA Council member for Singapore, Gregory Vijayendran, spoke so helpfully about the Singapore Convention, the future of mediation online and in person, and legislation. Now, that is particularly resonant in India at present with your pending legislation, but it goes to the heart of what I might call pure mediation, where the parties are voluntary participants and the mediator is purely facilitative. From that, indeed, can come about transformation in parties' attitudes and in parties' approaches. But can I just sound a small note of caution? We still live with a resistant legal profession, some of whom find it impossible to break away from the adversarial mindset. Those lawyers bring adversarial approaches into the mediation room, and that can sometimes result in a clash of an adversarial culture with a facilitative culture. Now, against that, without parties being willing to mediate, or even parties being told to mediate by legislation, there wouldn't be mediation. And to some extent, we as mediators have to confront what the market wants. And for some commercial parties, the market wants heads banged together. They don't want to be transformed into better people. They want a commercial, hard-edged resolution to their problem with robust in-mediation discussions, and where the mediator will engage strongly with them to point out alternatives and the consequences of maintaining a particular viewpoint. So while, of course, in mediation there is a place, and a very notable place, for peace building, for transforming and for making parties and our world a better place, there is also a commercial reality check, as we mediators like to say, whereby we have to respond to the market, and we have to some extent, adjust in the flexible process what the parties are coming to expect. And that has seen the development of mediator profiles, of mediators being interviewed, and if you like, to assess their approach. Are they facilitative or are they evaluative? And we shouldn't shy away from discussing the place of evaluation within what is often described as a facilitative process. So it was excellent to hear yesterday from Sola and from JP saying about mediation advocacy. But I do have some concerns about the trend and direction that some of our adversarial legal colleagues, they simply won't have the patience for dealing with the classical pure mediation approach of openings and exploration, listening attentively. They want to get quickly to a nitty-gritty. So in conclusion, and I could talk a lot about the need for training, and I've heard a lot this week about the importance of training for mediators. Ethics must be squarely central to the process for mediation training and behaviors. We need to go down a step and consider how we are training lawyers in law schools and why we are only training them in an adversarial mindset whenever a problem-solving mindset is gaining so much respect. We must ensure quality in the mediation process and in the mediators, and it is through those elements and collaborations that the CLA, for example, is having with Nivaran today, that we will truly advocate for mediation to become even more entrenched, respected, and used in our civil and commercial and other parts of our justice system. In conclusion, we need champions to speak about mediation, to argue for it, and there have been many champions emerging from the Nivaran Summer School, and it seems to me that mediation across the Commonwealth is in great heart. Thank you so much, Nivaran, for having me make these few words to you today, and I look forward to our next speaker very much. And thank you again, and happy Independence Day to the whole of India.
Thank you very much, Mr. Brian Speers. That was indeed a very deep thought and reflection, and it will take some time to sink in. May I now have the honor to call upon our chief guest, Honorable Justice P.S. Narasimha. Justice Narasimha is one of the brilliant legal minds we have had the opportunity to see and interact with, first as a counsel before the Supreme Court of India for many years, and now fortunate to have him as a judge of the Supreme Court. He was also the Additional Solicitor General before being elevated as Judge, Supreme Court of India. May I call upon you, sir, Justice Narasimha, to kindly share your thoughts about mediation as one of the appropriate dispute resolution mechanisms in times to come.
Thank you, Sheshadri. My former colleagues, so to say, Lakesh Khanna, Jitendra Mohan Sharma, Rajiv Datta is here, of course, Santana Krishnan, and I've just heard the brilliant speech given by Brian Speers. I have also had the opportunity of listening to some of the previous speakers, and I would also be referring to them a little bit. To start with, I want to congratulate the team Nivaran. There are two reasons for us to rejoice today. First, of course, is the 75th years of freedom that we have gained. And second is Nivaran's successful completion of the 10-day program, which is the need of the hour. I must congratulate you for having completed it successfully. To commence with, while we are very happy about the 75 years of independence, we also slightly reflect upon what we have inherited, as Brian Speers has specifically raised that point about the adversarial litigation. We have worked on this basis after independence for about 75 years, and before that for about 100 years. It didn't really work for us. The truth of the matter is that if two brothers simply want to partition their property and settle the inheritance amongst them, should the litigation continue for about 15 years? Every litigating lawyer is aware of this. And I have become more aware since last year, after I became a judge. Every third case that I pick up to decide is a litigation which is continued for about 15, 20 years. And I reflect upon it. It's so sad that there was never a need for the litigants to fight upon it. What has added upon the differences between the parties, I think, is not their inherent nature, but I think it is the methodology of resolution. That is what has contributed to simple, normal individuals becoming monsters against each other. And only the system has to be blamed for that. What really, it's necessary for us to reflect upon adversarial litigation a little bit more so that we will understand the real advantages of a mediation. Adversarial litigation, by its very nature, is based upon rights and duties. Also on what is right and what is wrong. This necessarily requires an adjudicating body to get into the question of what is the truth of a fact, to decide who is right, who is wrong. And once they start inquiring into what is the truth of a fact, fact could be even a state of mind, that necessarily takes them to evidence of the fact. And once you get into evidence, you are in the realm of what is relevant, what is irrelevant. Much of human life, our living, comprises of so many aspects of it, considering the vulnerability of human life, which is the most important thing that we must notice. All those aspects which law determines to be not relevant under the Evidence Act goes out of the window. So we end up determining the rights and duties on the basis of what is the evidence before the court, and this is the problem that I face every day. Though we know that the truth is not here, but then the material available is only that much. And I can't ask more, and I can't get away from what is shown to me as evidence, and I am compelled to accept that. In yesterday's speech, one of the speakers, I think George Lynn, has said, this is the fundamental difference. He has given an example of an accident claim between an insurance company and an individual, where the fact came forefront that the individual who was unable to contest the litigation wanted to get away, and he was in a suicidal condition. And his father stated that his wife is having cancer and his another son is in jail. These are completely irrelevant facts so far as adversarial litigation is concerned. But these are the very facts which compelled when parties sat for mediation to decide that this can be settled. The fundamental difference, my little experience as a lawyer and large experience as little experience as a judge and larger experience as a lawyer, is that I think mediation has a feature of a very, very important principle, that is fraternity. What it does is that it enables the person who seeks to mediate between the parties to try and bring about harmony with some amount of selflessness. And that makes all the difference. There was a great philosopher who somebody asked him, I believe, that how should we treat others? And a very simple definition he gave. He merely said, there are no others. It's a very profound statement. When he says there are no others, what he meant is your happiness is inextricably linked to the happiness of the society or your friends, relatives, and everybody around you. This is what a dispute resolution must recognize. And if we recognize that, then the fight for a right, fight for a duty, which is the fundamental basis of adversarial litigation, will be eschewed, and people will resort more for mediation for the purpose of settlement of disputes. I am not a professional mediator, and in yesterday's speech, I heard Reen saying that she was compelled to get into mediation because of circumstances. Exactly, that's the same position so far as I am concerned. When I was a law officer, solicitor for the government, invariably the court used to ask me to see if I can resolve the small disputes between the individuals who have come before the court against the mighty power of the government. And I got great amount of satisfaction when I could convince the governmental officials to agree with what is being suggested for the purpose of resolution. Lots of cases could be resolved. My experience in recent past, when I was called upon to resolve a decades-old dispute of the BCCI case, the cricket controversy, for which almost for 20 years there was no election to that. What's interesting here is, I'll come to that point a little later about the mindset of lawyers, as Brian has again. I come back to your speech again. I sat to resolve that very reluctantly because it was at the peak of my intense private practice after having resigned as a law officer. All my consultation is on the BCCI website. We have clocked about 120 hours of mediation. The point I'm making here is, as I sat with these people, the sports associations across the country, when they would tell me what the problem is, I would tell them what is the answer. I would judge whatever they had said. I would give my view of that matter, and I would also suggest solutions to the problems. It happened for 2 days. And then fortunately, I realized this is a habit that I have got in my mind. The habit that a lawyer develops as a trait for adversarial litigation. This is what we do all the time. When a client comes to you with a problem, you tell him how easily it can be resolved, or what are the judgments available on the point, or how the judge would react. This habit, I would rather say a dirty habit, so to say, to believe that you know everything and then give the answers even before a client would complete his sentence, or even an advocate who comes to brief you, the habit that a senior counsel has. I told myself I will not do that. And then I listened. Only thing I said, I will just listen. Only thing I continued to do for the 100 hours that I have over 6 months period is just listen. And I must tell you that worked. People, those who had severe problems with the other party, wanted somebody to just listen to them. And by listening, things melt. There are some people who have said, I don't need anything. Now, till now, I have not got even a single individual who would have told me, who would have heard me for some time. So these are, and I should let me complete it. What does it take? It actually, an involution. What it really takes is a change in your personality, a belief that he would know better to resolve his problems, and perhaps you could help them do that. You must reduce the ego, change in the personality, and permit people to come and offer solutions to the problems. It resolved by itself. There wasn't anything much for me to do. After that, the matter was resolved and it went for elections, and now there is an elected body to that. The point I'm mentioning is, I'll conclude with this. If lawyers are to develop as mediators, which is inevitable in our country, we are not considering, of course, there's a possibility of trained mediators other than lawyers, but substantial part of resolution, perhaps initial stage at least, will come from lawyers. So it's the training which matters. I was connected with the making of the legislation also, as I was a member of the MCPC, when we initially thought that we will move the institution from the corridors of the Supreme Court and make it accessible. And we called for a draft of the mediation committee, and there were competing views, and I had to reconcile them. And by the time I completed, the bill was before the government, and I was consulted by the government also. And at the right time, crucial time, so to say, that I had to become a judge, and whatever I could do with that came to a standstill. The Act talks about, there are 3 features in the Act which I want to highlight. If we are having a vision about mediation in our country, first and foremostly, where are the mediators? That's the question. This question is relevant for the reason that it is provided under the Act that no court will entertain a petition till a failure of mediation report is submitted. We had to think about it for a long time, but eventually it was decided that that clause should be there. So therefore, if a party cannot have an interim order before a court until a mediation gets completed, the question inevitably will arise once the Act comes into force, where are the mediators? If you don't have the infrastructure with respect to the mediators, then it's going to be a big problem. Number two, the Act talks about mediation service providers also, which means that these are the institutions which can be resorted to for the purpose of enabling mediation. How many such institutions are available, how many mediators are available, is a factor which needs to be considered, and particularly an organization like Nivaran must rise to the occasion. There is an enormous responsibility on your shoulders. So you must rise to the occasion, and you must ensure that other institutions like yours are not competitors to you, but they must also be given space, and you must all work together. The Act provides accreditation. The Act provides many other things. But as it is always the case, the working of the Act will certainly depend upon the chairman of the committee which the Act contemplates for the purpose of enabling success of mediation in the country. Nothing of that has come into play as of now, but then the freedom of profession that you all enjoy will enable you to come into the market and make your services available irrespective of the advent of the Act. The time has already started so far as you are concerned. Statute might only give you a overarching methodologies by which rules, regulations, and other things could be put in place. But otherwise, the system is open. So you must work towards that. You must work towards establishing mediation institutions where good amount of training will be imparted, number one, and ensure that credible mediation will be done through your ages. The last and most important aspect, it's a matter of concern. Mediation, the need for mediation is actually at the grassroots level. Mediation is not needed for social justice in the context of the corporates in our country. They will have their disputes resolved through arbitration or the higher courts or judicial. But really speaking, mediation is needed for social justice, and that happens and occurs only in the lower courts. Most important thing, therefore, is that mediation must be made available at the civil court levels. Court annexed mediation centers are there, but then we need to improve upon them and ensure that simple cases which affect the individuals' lives, like motor accidents claims, insurance claims, injunction suits, partition suits, matrimonial matters, for them mediation must be made available easily. That is where access to justice will really happen. Today, there is no access to justice for the reason that you can go to a court, but then the case will prolong for 15 years. That's no access to justice. But through mediation, it is possible. So my caution is that while you train lawyers to develop as mediators, emphasis should be to provide mediation in the civil court at the lowest level. I don't want mediation. I'm afraid that mediation could also be hijacked and become something like arbitration in India, which is more or less confined to corporates. The need of the hour in my submission is the availability of mediation. I have repeated the point, need of mediation at the lowest level. And if that is done, I think the purpose of mediation will be served. With this, I thank Nivaran for giving me this opportunity. And it was wonderful interacting with all of you. Thank you very much.
Thank you very much, Justice Narasimha, sir, for this very, very enlightening talk. Two very important takeaways from your talk is one of active listening, which certainly is one of the cornerstones of being a good mediator. And second observation that makes, I think, the entire mediation field very hopeful and all the mediators is that lawyers will need to become mediators at some stage. So certainly there is a hope that the mediation field will grow. Thank you very much for this very, very enlightening address, sir. Mr. Brian Speers, I think, wants to put in a word. If I may just hand over the mic to Mr. Brian Speers before I call upon Mr. Sanpreet Ajmani.
I just wanted to say how much I enjoyed Judge Narasimha's talk, and to say that I would love him to develop that thinking about the mindset of the lawyer and the need for lawyers to become almost inevitably mediators. And could he develop that at our conference in Goa next March, where I will arrange for an invitation to be sent, and it would be great to see you in person, sir, and to allow your wisdom to be shared with a wider Commonwealth legal community. And I didn't want the invitation, when it arrives, to drop with surprise in your letterbox, and thought it would be appropriate to say that we would love to see you in wonderful Goa in early March. Thank you, Mr. Ray, for letting me make those remarks, and to publicly say that an invitation will follow.
Thank you. I'll try. Surely.
Thank you, Mr. Speers.
Thank you very much.
Thank you, Mr. Speers. I now request Mr. Sanpreet Singh Ajmani, Head of the Youth Bar Association of India, to kindly give us the closing address.
Thank you so much, sir. Today in the eve, when we are celebrating the Platinum Jubilee of our Independence Day, I have been bestowed with the responsibility, rather an opportunity, to make a closing statement on this virtual summer school. Mediation, as we all know, is a wonderful process of resolving the dispute amicably. Through this process, the entire dispute is given a quietus to bring harmony between the litigating parties. I sincerely admire what Honorable Justice P.S. Narasimha said, and the three important aspects upon which he banked upon, and also about the worthy speakers. And we have always learned, my guru, Mr. Jiten Mohan Sharma, while making an address, has emphasized about the efforts made by Lord Krishna to resolve the dispute. He also quoted Gautam Buddha. Apart from that, he also cited the important scripture that is somewhere lying in Allahabad. I just quickly want to just share one important aspect, as Justice Narasimha said, and he was pained to note that every dispute, like a dispute of partition between the brothers, they are litigating for more than 15 years, and the matter is coming to the Supreme Court, and there the process comes to an end. But the dispute cannot be said to have been given a quietus, and it cannot be said to have been set at peace, because either of parties might have lost and one party have succeeded in the litigation. We always heard during the sessions, during the classes, about that two persons are fighting over an orange and one person would get or other would lose. But through the process of mediation, both the parties can succeed. So there is one judgment which I have shared in the chat box at 5:47 p.m. I want everyone to have a look over that. That is a judgment of the Honorable Supreme Court, 3 judges bench, presided by our Honorable Chief Justice of India, as he then was the judge. He emphasized not only, though two brothers were fighting over a leased shop, he not only emphasized for the mediation, but he requested the mediators to adjudicate the dispute between the two. So once, this is something, a very unique thing, where the Honorable Supreme Court has bestowed the responsibility upon a mediator to even adjudicate the matter. One of the unique in itself. But The moment such a order comes, both the parties will put forward their claims, and the mediator would have the liberty to understand the dispute and decide it in an amicable way. So by all this, I thank once again to Honorable Justice Narasimha to be very kind and to educate us and to tell us about the important aspects. He told us about the three methods that from where the mediators would come. He also emphasized upon the social justice. He said that the mediator must be available at the lower courts, at the subordinate courts, so that the disputes like small disputes and matrimonial disputes, injunction disputes, partition matters, that can be resolved at the initial stage, rather going through the lengthy process, because this is the most efficient process that the dispute would be resolved. It's cost effective. It's otherwise also. So finally, I may simply deliver my closing address by giving vote of thanks to my guru, Mr. Jitendra Mohan Sharma, Senior Advocate, Mr. Rakesh Khanna, Mr. Brain Speers, the guest of honor for today's program, Mr. Santan Krishnan. And I was also saying on screen, Mr. Rajiv Datta, Senior Advocate, my worthy senior, Mr. Ray, and last but not the least, Mr. Rahul, who is behind in organizing all these events. Thank you so much.
Thank you, Mr. Ajmani. We thank all the participants who attended this International Virtual Summer School 2022, and we hope you all have greatly benefited from the intensive course by a very enlightened guest faculty over the last 9 days. Needless to mention, each will be receiving a certificate of participation. We look forward to having you back on this platform on Nivaran's other endeavors and programs, including hopefully continuing this annual feature of the Virtual Summer School. And before I say goodbye, a few acknowledgements are in order, which Mr. Ajmani has already said so, but nevertheless, the first goes out to Team Nivaran and its primary think tank, as well as Mr. Rahul Advocate and his team who have supported this entire virtual effort seamlessly over the past now 11 days. A big thank you also goes out to Mr. Jawad, who has spent valuable time from his busy schedule towards his efforts in organizing this event. Thank you all very much. Jai Hind.
Thank you so much. Thank you, Shesh.
Thank you. Thank you so much.
Thank you. Thank you very much, Shesh.
Thank you all.
Sir.